Hello, my name is Cleveland Simmons, and I'm a partner at Seacrest Wardle in our Troy, Michigan office. Today I will be presenting a webinar about liability for animal attacks. The main purpose of this webinar is to provide context relative to landowner, property owners, landlords, and the like in premises liability situations. We typically think of animal liability in terms of the animal's owner. However, a plaintiff may also recover from a landowner even when the landowner is not the owner of the animal. In Michigan, liability for animal attacks can be split into two categories: common law theories of liability for animal attacks and statutory strict liability for dog bites. There are three common law theories for animal attack liability. These theories are strict liability, negligence, and common law liability for landowners. Common law strict liability applies to the owner or keeper of a domestic animal. Generally, domestic animals include dogs, cats, and birds. However, pigs, cows, horses, chickens, and other animals have been considered domestic animals when they have a specific relationship with their human outside of the usual situation we typically envision these types of animals in. Under common law strict liability, the owner or keeper of a domestic animal is liable for damages caused by that animal when the owner or keeper knows or should know of the animal's dangerous or vicious propensities. As you can see, there are several elements to common law strict liability. The easiest to spot is ownership. If you own the animal, you will be strictly liable for bites or attacks of that animal, assuming the knowledge requirement can be established. However, what if you're not the owner of the animal? Then we must determine if you are a keeper of the animal. Notably, a temporary custodian, caretaker, or babysitter is not considered a keeper of the animal for common law strict liability purposes. However, what if you're not the owner of the animal? Then we must determine if you are the keeper of the animal. Notably, a temporary custodian, caretaker, or babysitter is not considered a keeper of the animal for common law strict liability purposes. As the Michigan Supreme Court ruled, a temporary caretaker has no choice regarding whether the dangers an animal presents will be introduced into the community, nor have they agreed to shoulder responsibility for injuries the animal may inflict. Basically, if you're just temporarily watching someone's domestic animal, you will not be strictly liable for that animal's attacks. However, you may be liable under other common law theories, which we will discuss later. The most important element in common law strict liability cases is whether the owner or keeper knew or should have known of the animal's dangerous propensities. We have all heard stories involving pit bulls attacking people. However, in Michigan, dog breed does not matter. In fact, our courts have specifically ruled that pit bulls are not categorically dangerous under the law. Additionally, the Court of Appeals has ruled that the breed of a dog is irrelevant to the issue of damages and more prejudicial than probative. Therefore, even with pit bulls, common law strict liability only attaches where the owner or keeper knew or should have known of that particular dog's vicious propensities. The question you must be asking yourself now is, at least in the context of dogs, if the breed of a dog is not relevant, then what about the animal's history of previous bites? Is the history of an animal conclusive evidence of viciousness, and is that sufficient to satisfy the requirements of common law strict liability? The answer is not so straightforward. In Veal v. Spencer, the Court of Appeals ruled that evidence of previous bites is relevant in determining whether the owner or keeper knew or should have known of the animal's violent propensities. However, the mere fact that an animal has bitten or attacked someone in the past is not evidence that the animal should be considered vicious as a matter of law. Therefore, prior attacks will be taken into account, but it is going to come down to what the owner or keeper knew or should have known about the animal. Similarly, normal animal behavior is not evidence of dangerousness. For example, dogs bark, growl, and jump on people. This is all normal dog behavior and is not admissible to prove viciousness. Knowledge of an animal's alleged dangers is something that will be determined on a case-by-case basis. The fact that a dog breed is generally viewed as dangerous, for example pit bulls, does not matter. What matters is, did the owner or keeper know that specific animal was dangerous? As previously discussed, common law strict liability applies to domesticated animals, which could include equine animals such as horses, mules, or donkeys. However, in most equine situations, there is immunity for an attack. In Michigan, we have the Equine Activity Liability Act, which grants immunity from tort liability in situations where the owner is an equine professional for compensation and the participant sustains injury as a result of the inherent risk of equine activity. Michigan courts have ruled that even those visiting, touring, or using an equine facility or stable are considered participants under the EALA. Additionally, equine professionals must post and maintain conspicuous warning signs in the area where equine animals are kept. Now we will get into common law negligence for animal attacks. Generally, negligence in Michigan is simply stated as duty, breach of duty, and causation. However, in the animal liability context, it must also be proven that the owner, keeper, or temporary caretaker knew or should have known of the animal's dangerous propensities. Notice the difference between common law strict liability and common law negligence for animal attacks. In common law negligence cases, even a temporary keeper can be negligent for an animal attack. Also, the protections of the EALA will not apply to an equine animal attack when the owner is negligent. Dogs are generally regarded as so unlikely to do substantial harm that their owners or keepers have no duty to keep them under constant control. The mere failure to do so does not constitute an automatic breach of any duty. However, when the animal's dangerous propensities are known or should be known by the owner, keeper, or temporary keeper, then there is a duty to keep the animal under control. Even so, in situations where there is no knowledge of the animal's dangerous propensities, the owner, keeper, or temporary caretaker can still be liable for negligently failing to restrain the animal or to prevent harm by the animal. Again, just like in common law strict liability cases, in common law negligence cases, normal animal traits are not conclusive evidence of dangerousness. Now we will discuss how landowner, property owners, and landlords can be liable for animal attacks. Obviously, if the landowner is the owner, keeper, or temporary keeper of an animal, then one or both of the previous common law theories we discussed will apply. However, the more difficult fact patterns involve cases where the landowner leases or rents the property to a tenant and that tenant's animal attacks someone. Similar to common law negligence for owners and keepers, a duty is only imposed on a landowner for an attack by a tenant's animal when the landowner knows or should know of the animal's dangerous propensities. However, it is important to note that the mere failure to enforce rules regarding dog breed or size does not by itself create a tort liability on the part of a landowner. Another issue that comes up relative to a landowner's tenant's animal is, does a landowner have a duty to protect third parties off premises? Generally, no. Landowners do not owe a duty to protect third parties from attacks by a tenant's animal that takes place off the leased premises. However, a landowner may be liable for off-premises attacks when the landowner knows or should know of the animal's dangerous propensities. Another issue that comes up is whether there is a duty to inspect the premises for dangerous animals. After the premises are leased, there is no separate duty for the landowner to inspect the property to discover the existence of a tenant's dangerous animal. However, when the landowner knows or should know of the animal's dangerous propensities, negligence will attach if that landowner does nothing and the animal attacks someone. The other way landowners may be liable for animal attacks is in a premise liability case. In premises liability actions, there is potential liability when a condition on the land causes damages or injuries. Therefore, in premises liability actions, the question is, can an animal be considered a condition on the land? In Clemic, a loose, unsupervised dog, either on the property owner's land or in close proximity without a fence to prevent the dog from entering the adjacent land, was considered a condition on the land within the meaning of a premise liability action. A key to that decision was the fact that the property owner was aware of the dog's prior bites. The court also found that the property owner owed a duty to exercise reasonable or ordinary care to prevent injury to a child social guest because he was aware of the dog's prior bites. As we can see, even in situations where an animal may be deemed a condition on the land, it still must be proven that the landowner knew or should have known that the animal posed an unreasonable risk of harm. Now you may be asking yourself, what if a landowner allows a friend or family member to bring an animal to the landowner's property, but the landowner is not watching or keeping the animal? For example, think about a barbecue or a backyard party where the landowner allows people to bring their dogs. In these situations, where the landowner does not know of the animal's dangerous propensities, the landowner cannot be liable for their guest's animal attacking someone on their property. The victim's exclusive remedy would be against the animal's owner. An innkeeper owes a duty to protect its guests from injury. MCL 125.474 provides that the owner of every dwelling shall be responsible for keeping the entire building free from vermin. In one unpublished opinion, a plaintiff was bitten by a spider in defendant's hotel. While acknowledging spiders are vermin, the hotel argued that it complied with its duties in treating plaintiff's room 2 months before the incident because the pesticides had some residual effect. Plaintiff countered that the hotel's failure to treat all rooms monthly to ensure effective pest management was a breach of its duty. With these competing arguments, the Court of Appeals found a question of fact remained as to whether the hotel breached its duty to the plaintiff under the Innkeeper's liability statute. The lesson here is even animals you or your business do not harbor could be the cause for potential liability. The other theory in Michigan is statutory liability for dog bites. Statutory strict liability for dog bites is exactly that, liability for dog bites only. Also, dogs are not allowed one free bite in Michigan. The dog bite statute imposes almost absolute liability on the owner of the dog. Notably, viciousness of the dog or the owner's knowledge of the dog's viciousness does not matter. This is a significant diversion from the common law theories we previously discussed. Dog bite victims often try to impose statutory liability on property owners when the dog is owned by a tenant. However, Michigan courts have routinely rejected these arguments on several occasions. Similarly, a temporary caretaker or keeper of a dog cannot be considered the dog's owner within the meaning of the dog bite statute. 24-hour possession, control, and care of a dog will not automatically make a person an owner of a dog. Dog ownership must be actual, specific, and not just perceived. Now we will discuss defenses to animal attack claims. In common law actions, a landowner does not owe any duty to a trespasser except to refrain from injuring the trespasser by willful and wanton conduct. Basically, you cannot set a trap to induce someone to come onto your property and get bit by your dog. In this case, the trespass defense will not work. Additionally, under the dog bite statute, a trespasser is not entitled to any recovery. A dog bite victim must show that he was an invitee or licensee in order to be protected by the dog bite statute. Even a slight or incidental trespass onto property is enough to trigger the trespass defense in a dog bite case. However, if an implied license to enter the property was given, such as in a garage sale context, then the trespass defense will likely not be applicable. There is an absolute defense to claims brought under the dog bite statute when the victim provokes the dog. Typically, provocation is an intentional act. However, unintentional acts satisfy this defense as well. In one case, a plaintiff unintentionally stepped on a dog's tail and was bit in the leg. The court looked at the definition of provocation and found that the intent of the victim was not relevant to determining whether the victim provoked the dog. Additionally, some intentional acts are not provocation where the dog is already in an aggressive and violent state before the victim makes contact with the dog. In an action based on tort or another legal theory seeking damages for personal injury, including the common law claims we previously discussed, a plaintiff's award of economic damages must be reduced by the percentage of fault allocated to the plaintiff. On the other hand, if a plaintiff is deemed to be more than 50% at fault, then non-economic damages will not be awarded. Unfortunately, comparative fault is not considered in a statutory dog bite action. If there is provocation or trespass, then there are absolute defenses. But anything short of that is insufficient to relieve the owner of liability under the statute. Just a few practice notes before we wrap up. Evidence of prior bad or good behavior of a dog is not admissible nor relevant in a statutory dog bite action. Such evidence is also irrelevant to a finding of liability under the statute. Also, a plaintiff can't present both statutory and common law claims in one case to a jury. Here are some takeaways in the premises liability context for landowners. If you are the landowner and the dog owner, you will be subject to common law and statutory claims. Landowners can be liable for their tenants' animals, but they must know or should know of the animal's dangerous propensities. Dog breed does not matter regardless of the type of case. A carefully crafted pretrial motion in limine on this issue must be filed, especially if the dog breed involved is generally seen as dangerous in the eyes of the public. A landowner's failure to enforce rules about dog breed and size is not a breach of any duty. Again, it will come back to what the landowner knew or should have known about the specific animal at issue. Because a plaintiff can plead multiple theories, it is important to carefully examine plaintiff's complaint and move for summary disposition on any and all claims that can be dismissed. The more claims that can be presented, the better chance for a large recovery. Therefore, it is always important to narrow the issues as much as possible before a trial. Thank you for listening to this webinar on liability for animal attacks. If you have any questions or want more materials on this subject, please feel free to contact me at your convenience.